Good morning, Your Honor.
Good morning. Maybe you should turn your computer towards the light if you have a laptop because we can't really see you. Can see a shadow of you. Usually you have your computer towards the light or turn all the lights off or shut the drapes and turn the computer towards the
Okay.
light.
Okay.
Okay, that's a little better. All right. Maeve is putting it on live streaming. It seems to be on. It's now being live streamed. She'll call the case. Thanks.
Calling case number 25012007-AW. Davis v. Winfrey. Please state your appearance for record.
Good morning, Your Honor. May it please this honorable court, Robert Davis, pro se plaintiff.
Good morning.
Good morning, Your Honor. Ben Patterson on behalf of defendants with the City of Detroit Law Department.
Good morning. All right. Did someone who wants to speak first?
Your Honor, I would like to start, Your Honor. Your Honor, we had a hearing on November 14th in which on the record, an agreement was reached that I would be allowed to file an amended complaint that was to be filed on Monday, November 17th, inclusive of additional facts that occurred on election day after this court very graciously held an emergency hearing at 7 p.m. on election day on November 4th, and that I was going to include additional facts as it relates to what occurred after the polls closed on November 4th after 8 p.m. and to add additional claims that formed out of those additional facts. I did, after the hearing on November 14th, I sent an email to Mr. Patterson asking who would be drafting the order. He requested that I do it. I drafted a proposed order in which I sent to Mr. Patterson. Mr. Patterson had some suggested changes. After I incorporated his suggested changes, he agreed to the entry of the order that was submitted to the court on November 14th. That proposed stipulated order was agreed to, its language, by Mr. Patterson in writing via email exchanges. In accordance with the language of the proposed stipulated order in which Mr. Patterson agreed to in writing, and that was promptly submitted to the court on November 14th, in accordance with the terms of the order, I timely filed the second amended complaint with the court on Monday. The clerk's office indicated that my second amended complaint was being rejected because the proposed stipulated order allowing its filing had not been signed and entered by the court. I immediately informed the court of the clerk's office message through the MyFile filing system, which Mr. Patterson also received a copy of their rejection of the second amended complaint based upon the fact that the order had not been signed permitting its filing. And then Mr. Patterson sent an email to the court indicating that he was somehow withdrawing his approval of the order based upon my second amended complaint, adding a due process claim that flowed from his client's unlawful conduct on November 4th. Since that time, the court has not entered the proposed stipulated order, which was agreed to by Mr. Patterson in writing, and here we are today. The second amended complaint that was filed is fully complies with the language of the.
All right, Mr. Davis, if I could stop you right there. I'm going to hear you out on this, but I want to say just for the record that until your last sentence, everything else, I think probably, that everything else, I agree with. There was a hearing on November 14th. There was a stipulation to an amended complaint and all of that. But the last part, before your last sentence, you said that Mr. Patterson indicated that he wanted to withdraw because of the additional claim, which that's why we're here. I believe that's why we're here. So you can tell me how you think that the addition of an additional claim still fits into your stipulation, and he can tell me why it doesn't. But it seems to me like there's two choices here. Either you withdraw the additional claim and we'll move today on what you have so far, or you have file a motion for amended complaint that does include a new claim, or the two of you agree to whatever within that realm you can agree to, because from what I see on the record, we did have a hearing on November 14th. You did indicate you wanted to file an amended complaint and indicated that you wanted to have additional facts to support your complaint. And you did not mention additional claims or counts. And you alluded, as a matter of fact, I did look at the record, and it said that that the defendants actually should not have an objection because they can bring the same motion for summary disposition with respect to the proposed second amended complaint. So that would be indicating that there are no additional claims, and you reference only the existing claim for declaratory relief and use the term during that hearing, same claims. So if you two want to talk, I don't want to interfere with any stipulations. If you guys have some stipulations that you can work out yourselves, I'm good with it. If you want to argue to me right now that it still should be within the realm of what you agreed to, but it seems from the outside that there's not a real meeting of the minds about what was agreed to, and that's why the court can't force something without the two of you talking to each other. Did you talk to each other?
No, Your Honor, and here's my position, Your Honor, respectfully. I think I clearly stated on the record the need for the additional facts was based upon the additional claims that formed as a result of the defendant's unlawful actions. And those particular issues could not be addressed based upon the counts and allegations set forth in the first amended complaint, because those additional facts occurred after the court held its emergency hearing on November 4th at 7 p.m. in the evening. And even the court agreed that went into great detail, some detail, not great detail, of how the things that occurred on election day after the polls closed could not be addressed at your 7 p.m. emergency hearing. And
The
which is why,
facts of what happened, not the claims.
well, the facts of what happened, as I indicate on the record, includes the additional claims. The additional claims, Your Honor, is why the additional facts have to be pled.
Okay, let's hear from Mr. Patterson for just a moment, because the record didn't indicate any understanding on his part about additional claims. So, Mr. Patterson?
That's correct, Your Honor. When we had the hearing, Mr. Davis, I guess the main issue is this brand new allegation for the first time for money damages. At no time during the hearing on November 14th did Mr. Davis indicate that he wanted to add a claim for money damages. And even the title of the filing is Second Amended Complaint for Declaratory Judgment. When I looked at the document, buried on page 21 in a subsection was an allegation under a claim seeking $250,000 in money damages under Section 1983 on a federal constitutional claim. That's not at all what was agreed to. I never would have stipulated to allow Mr. Davis to add a money damages claim in an election case. So that's why I sent my email indicating that if that is what he wanted to do, he needed to file a motion to obtain leave of court to file a Second Amendment complaint. So the money damages is the issue. That was never disclosed, never asked for. I was very surprised when I saw it. And if Mr. Davis wanted to add a money damages claim in this election case, he needed to obtain leave of court to do so. That's not what I stipulated.
Okay, thank you. We're back to the space where Mr. Davis could, disregarding the additional claim, proceed, or you can just file a motion to file a second amended complaint with new claims and requests for money damages. Either one, or, you know, how do you want to proceed at this point, Mr. Davis?
Your Honor, surprisingly, Mr. Patterson does not have a problem with the additional claim of declaratory relief under the Michigan court rules, declaring that his client's actions on election day violated Michigan election law. Is that, Mr. Patterson, you didn't have a problem with that additional claim, correct? Which is clearly stated.
It would be subject to dismissal on a motion for summary disposition. And the entire point of the hearing on November 14th was to try to cut to the chase and do this in an efficient manner for the court to resolve it. And that's why we set out a briefing schedule. What I was surprised at was a claim for money damages in an election case. Otherwise, I was going to be filing, as you stated in the record, my same motion for summary disposition. But when you add a money damages claim, it's probably doubles the size of the motion.
And Your Honor, yes, I just wanted to make clear that I did state on the record that additional claims based upon the new facts will be added, which is why Mr. Patterson doesn't have a problem with the new declaratory judgment claim that was added based upon what occurred on the night of November 4th. And what I'm saying is, in terms of, with respect to adding these, it seems as if that his only issue is the Section 1983 claim, is that the Section 1983 claim forms out of the same transaction or occurrence of the facts that occurred on election day. So under case
Mr.
law,
Davis, if you want to get a you know, a transcript, I didn't see that, and we had the referenced only the existing claim for declaratory relief. You used the term same claims. There was no and additional facts. I did not in any way find any kind of discussion or agreement between the two of you that would seem like a meeting of the minds of an additional claim, additional separate claim. And so for that reason, I cannot just say that this is a stipulation that includes an additional claim for money damages, and that was the understanding. I can't find anything that would support that understanding. So we can go round and round, but we're not going to anymore. We are either you want to file a motion for leave, the court will entertain it. I can't do anything else today.
well, Your Honor, here's just from my argument for the record. The order that he agreed to, which he cannot withdraw, the second amended complaint complies with the plain language of that stipulated order that he agreed to.
You can't show that today without showing some evidence that it does. He is solid on the fact that it is a completely different claim for money damages. It would not, you did make the statement that he would be able to bring the same motion for summary disposition. So there's, again, you want to go around and around.
I'm not going, I don't want to go around and around.
You are though, Mr. Davis.
Okay, so
He's not going to change his mind, and you're not going to change yours, and neither of you have. You want to reference specific statements in the transcript after you've ordered it, then I can entertain them. But we've reviewed the transcript here, and I don't see it. I don't see where you said there are going to be additional claims, and this could be one of them. Could be money damages. Nothing to that effect whatsoever. Could we find?
Your Honor, I would not have a problem filing a motion for leave to file the second amendment complaint. Okay. And I wanted to make the record clear, Your Honor, that Mr. Patterson did not have an issue with the filing of the second amended complaint that includes the state law declaratory judgment claim that was new based upon the new additional facts that occurred on election day. That's what, there are two new claims in the second amendment. So it's your
position that there is a new claim for declaratory relief.
That is correct.
Okay, Mr.
That's why
Patterson, could you address that? Because we need to have specific issues addressed. Mr. Patterson.
Your Honor, because that would be subject to dismissal based on the same motion for summary disposition that I've filed twice before, I had no problem with that. The issue was adding money damage claim. That was never disclosed. I never stipulated to adding a money damages claim.
Okay, so again, we've heard it 3 times. He is not stipulating to the money damages claim because it is not subject to the same motion for summary disposition, which was definitely both sides had made statements that the reason why there could be any kind of stipulation would be because it would be entertaining the same motion for Mr. Patterson for summary disposition. So we will allow you to file, Mr. Davis, and that's it, all we can do today.
So, Your Honor, just so I could be clear that the only thing that is at issue with the motion for leave to file a second amended complaint is the federal claim, the 1983 claim, correct?
Mr. Patterson?
If Mr. Davis removes that claim, we can have the stipulated order entered and he can file a second amended complaint without that claim.
Okay, so those are the 2 choices.
So
And
when would you like the motion for leave filed, Your Honor?
as soon as possible.
I will get that filed. Is the court open Wednesday?
Yes.
No. Oh,
It is. It's closed Thursday and Friday.
Okay. Your Honor, I can have the motion for leave filed by Wednesday.
Okay.
And when can we hold a hearing on the motion for leave, Your Honor, or is it?
Not on Wednesday.
No, I know that. I know that.
Yeah. Yeah, we can hold a hearing on it.
The following Friday?
Are you both available the following Friday? What's that date?
That would be the 5th, I believe, December.
How's December 5th? Yes.
Well, Your Honor, just that would give me all of my time to be filing an opposition would be during the Thanksgiving holiday. Because it would be on the 4th. So could we do the 12th instead? December 12th?
That doesn't seem unreasonable since there does have to be another response specifically to the added count money damages. So, yes. All right.
Thank you, Your Honor.
Thank you.
What time, Your Honor?
Do you know what the 12th looks like, Mavis, as far as docket? Could we give them, I mean, we want to do the really quick cases first, so we could either give you 10, probably 10.
10 would be typical. Right now, we don't have a super heavy docket for the 12th. Most things are on the 5th.
All right, thank you.
Thank you, Your Honor.
All right, bye-bye.